Please go to the podium. Good morning.
Good morning.
How are you?
We're fine.
Okay. So as my team supports me in setting up the machines for use, may I take this opportunity to sincerely thank all of you for coming this morning. This judgment was supposed to be delivered on 15th of March this year. But in the course of the week, I discovered that I had a free Friday, which is today, because the matters that I was supposed to hear today were not going to take off. And as you are aware, the last time I was in this court, the judgment was ready. It's only that one of the accused persons was indisposed. And I had also given an indication that I will be proceeding on leave with effect from the 12th, which is on Monday, for 1 month. So I thought it would be in the interest of justice to bring this judgment forward and deliver it today. And I did cause the lawyers and the parties to appear before me on Wednesday morning and indicated that I was going to deliver this judgment today. And I hold the view that the directions the court gave, based on the understanding of the parties, is still the same, that we are ready to take the judgment today. So may I just have a confirmation from the parties that we agreed that the court can deliver the judgment today. Thank you.
Good morning, my lady.
Good morning to you.
In this matter, I'm Hassan Nando. I appear for the first accused person. On behalf of the first accused person, we are ready to receive the judgment. Mr. Factual, alongside with Ms. Nicholas and Mr. Nguna, they continue appearing for the second accused person. They are equally ready to receive the judgment.
Okay. Okay.
I also appear alongside with Mr. Ayua, who I'm holding this brief, who will be joining us shortly.
Okay. Yes.
Good morning, my name.
Good morning.
On
On behalf of the prosecution, this is Ms. Ogweda together with Ms. Factual. We are holding brief for Ms. Kimani. And for the deceased family.
Sorry, what's the name of your colleague?
She's called Ms. Factual.
Oh, Factual, yes.
Together with the deceased family, we have Mr. Museli. We are ready to take the judgment.
Okay, that done. May I establish whether the accused persons are in court, so we will now officially call out the matter court assistant.
Criminal case number 51 of 2018, Republic versus Joseph Kuria Irungu, Elias Jowie, and Jacqueline Wanjiru Maribe.
Okay, so both accused persons are in court. I believe the lawyers were speaking on behalf of their clients that they're ready for the judgment.
Yes, that's one.
All right, good.
Both accused.
For both, yeah, okay. So I think we are good to go. If there is a party who would have liked to attend to the hearing of these proceedings and may not have been notified because of the change in the date, I apologize in advance. But based on what I can see, I think generally there must have been adequate information and notice that the judgment will be delivered today. I had been given an indication that this judgment will be delivered both physically and virtually. May I have a confirmation as to whether that is the position court assistant? That's what I was told by the Honorable DR.
There is a team at the judiciary report who was supposed to come and set up their equipment to do.
I'm sure they are not hearing what you are saying.
I'm saying there is a team from the depot who was supposed to come and set up today morning.
Can you hear what he's saying?
No.
But can you hear what I'm saying?
Yes.
There is a team from the judiciary, which is the depot, which was supposed to come up today and set up everything in the morning. They were communicated by the deputy registrar. They were supposed to come here to set up before 8:30, but by the time we were starting, they had not yet come to set up there.
Maybe they're still on the way. They will come.
Yes, they.
Okay?
Yes.
But we'll proceed, and I'll proceed to give the judgment. Now, the counsels in this matter, if I read my judgment word for word, most likely will do 4 or 5 hours. My suggestion with your concurrence is this, that I do not have to read the entire extract from an authority that I've quoted. And I do summarize the same. If we are in agreement, I can do that. And the reason is, this is a technical area. And I want to assure you the judgment is here. I will not sign this copy here because this is a copy that, in my understanding and to the best of my knowledge, is not proofread for good reasons. So as soon as I'm done, I'll give it to the team to proofread it, correct any typo errors. I am hoping and I'm available to sign the copy before end of day. Okay? So you still have an entire judgment as soon as I'm done. But if you want me to read the entire judgment, no hurry, I'm available. I will read it.
My dear, on behalf of the first and the first and the second person,
Yeah, may I have some water, please?
and the council's on record, we concur with you and you consent that you only read the elements that are necessary so that we can be able to proceed.
Okay. So today I sit in this court to deliver judgment in criminal case filed at the High Court in Nairobi, being High Court criminal case number 51 of 2018. The Republic is the prosecutor in this matter. Joseph Kuria Irungu alias Jowie is the first accused person, and Jacqueline Wanjiru Maribe is the second accused person. I will give a factual background to this matter just to set us going and for ease of understanding. The two accused persons are jointly charged with the offense of murder. That is an offense established under Section 203 of our Penal Code, Cap 63 of the laws of this country, and that section is usually and generally read together with Section 204 of the Code. May I request that all our phones, so that I don't get disrupted, be switched off kindly? Thank you. So the particulars of the offense the two accused persons are charged with are that on the night of 19th of September in the year 2018, at an unknown time at Ramuria Gardens Apartments, Kitale Lane off Dennis Pritt Road in Kimani area within Nairobi County, jointly with others who are not before the court, they murdered one Monica Nyawira Kimani. The information and/or the charge was read to each accused person, and they entered a plea of not guilty, and the case proceeded to full hearing. The prosecution called a total of 35 witnesses, whereas each accused person offered their defense. The first accused person offering his defense through a sworn statement, and the second accused person opting to defend herself through an unsworn statement. None of them called an additional defense witness. The prosecution case is that the deceased person was at the time of her demise residing in Juba, South Sudan. She was working as a managing director of a company which was a family business company known as Millport General Trading Company Limited, which was situated and or operating in Juba, South Sudan. According to the evidence that I have been able to establish from the court record, and more specifically the evidence of PW9, the security manager at Kenya Airways, the deceased departed from Juba on the 19th day of September 2018 at 3:58 p.m. on a flight KQ 353 to Nairobi, and arrived at the Jomo Kenyatta International Airport at 5:45 p.m. The court was given the benefit of the passenger manifest, and it indicated that the deceased or the material debt used a passport number CE034168, and her ticket number was 706-200-860623. She sat on seat number 28A. In addition to that evidence, the court had the benefit of the evidence of PW18, Teddy Mugambi Kiaria, who is the head of surveillance at the Kenya Airport Authority. Her testimony to the court was that she received a request from the Director of Criminal Investigations to provide CCTV footage of the movements of the deceased person on the material date. She then went and made an observation on the same in the company of the investigating officer, and it was revealed that when the deceased alighted from the flight, it was at 17:38:19 hours. And by 17:41 hours, she was at the immigration desk. She went to the baggage hall, picked her luggage, and exited towards the international airport stage by 17:51:10 hours. The evidence of Okech Otieno John, who testified as prosecution witness number 6, is to the effect that he operates a taxi. He received a request from the deceased person He responded positively, and that was about 6 p.m. He picked her up from the stage using his taxi registration number KCQ 399C Nissan Wing Road and dropped at the destination, which was Dennis Pritt Road, Kitale Lane. As is expected, he was paid his dues and left. The witness indicated that before they go to Dennis Pritt, the deceased called a border rider whom she met at Nyayo Stadium, according to his evidence, and handed over an envelope to him. According to him, their time of arrival at Ramura Gardens was about 7 p.m. And as I've already said, he was paid and left. The evidence of the prosecution protected witness number 3A is the guard at Ramura Gardens. And his evidence is that when the deceased arrived at Ramura Gardens, she picked her house keys and her laundry, which had been left at the sentry house by the person who was working in her house in the day, and they were left with the day guard. It is his evidence then after she picked those items, she proceeded to her apartment, which was apartment number A8. It is the prosecution case. Thereafter, the deceased was visited by 4 people on that night. According to that protected witness, PW3A, the first visitor whom we had the benefit to allow to have access to the deceased house arrived at about 8 p.m. He arrived in a taxi, and he was a male person. He was dressed in a white kanzu, a gray jacket, and a maroon cap. Upon being asked to identify himself, he identified himself as Haron and gave out an identity card in the name of Dominic Becerra Haron. His request was to be allowed to go to the deceased house. The guard's evidence is that they called the deceased to seek for authority to allow the visitor, or otherwise, they were given authority, they allowed the visitor, and the visitor proceeded to the deceased house. The next person who was in the deceased house on the material night is PW7, Lee Owen. His evidence is that he arrived in the deceased house at about 9:15 p.m. He had gone to the deceased house, having met the deceased earlier, having had a discussion with her, and he was going to pick documents from the deceased. Owen testified that when he got to the deceased house, he found the deceased in the company of 2 male persons. One was Mr. Waridi, a neighbor of the deceased person, and an occupant of apartment number A9. A neighbor and an occupant of house apartment A9. The second person whom Owen found in the deceased house was introduced to him as Joe, a security officer with Interpol and Office of the President. And so, as I've indicated, the evidence reveals 4 people visited the deceased on the material night. At this point, we are at 3 persons: Mr. Waridi, a neighbor, Mr. Owen, PW7, and one who was introduced as Joe and who was cleared at the main gate as Dominic Becerra Haron. Anton Kariuki Kaka, PW16, testified that he visited the deceased person, my apology, on the material night. His evidence is that he did not gain access to the deceased house as the deceased opted to meet him at the parking area. And the reason why the deceased opted to meet him at the parking area is because the deceased informed him that he was having guests in her house who included a guy from State House. And so their conversation was held and ended at the parking area. It was the evidence of Mr. Owen, PW7. There was a general talk as they sat in the deceased house. 3 gentlemen and the deceased. And that the first person who left the deceased house was the neighbor, Mr. Warid. It is the evidence of Owen that he was the next person to leave the deceased house. And it is further evidence of Owen that by the time he left the house at about 10:40 p.m., he left the deceased in the company of the visitor who had been introduced as Joe. It is the evidence of PW3A, the protected witness, the guard at Ramuria Gardens, that the last person to leave the deceased house was Dominic Becerra Harun, who left at hours 23:21. And that after that visitor left, no one else went to the deceased house. The evidence of PW10, the brother of the deceased, George Kimani, is to the effect that the deceased who had traveled from Juba on 19th of September 2018 was scheduled to travel to Dubai the following day. But she had indicated to her mother that she would see her before she leaves. And so the family tried to reach her because she did not visit the mother. And so the brother's evidence is that since her calls were not being answered, he chose to go and check on her at her residence. He went to her house in the company of his girlfriend. And when they got to the deceased house, they couldn't access the house because the door was locked. And so they sought help from the caretaker at Ramuria Gardens. The caretaker testified as PW13, one by the name of Regan Irungu Buruku. It was his evidence that when the deceased brother sought for assistance to access the deceased house, he instructed the gardener, one by the name Stephen Wanjoy, who testified as prosecution witness number 14, to get a ladder, as they had discovered that the window and or door to the balcony was not completely closed. So the gardener got the ladder, got to the balcony and managed to access the house. It was the evidence of the gardener that when he got into the house, he found the television was on, water was running in the bathroom, but there was no one in the sitting room or in the bedroom. He proceeded to the bathroom and found the deceased body in the bathtub. There was a mobile phone next to it, and there was water running over the body from the telephone shower. It was his evidence, as of course would be expected. He went into shock and immediately notified the caretaker and the brother of the deceased, whom he had left outside the house. He then requested the door be broken so that they could gain access. that was done, and subsequently the matter was reported to the police. Among the officers who visited the scene is Corporal Jennifer Sirwa, number 75179, who testified as prosecution witness number 2. Her evidence was simple. She processed the scene and she took a total of 50 photographs of the scene. Those photographs were taken from various points, indicating various areas and items, which included but not limited to the general view of Ramuria Gardens apartments, closer view of Block A, where the apartment of the deceased was. There was evidence that there was a yellow bag whose contents were not disclosed, hanging on the door. Was a photograph to that effect. The sitting room, the bedroom, the personal effects were photographed. The body, and those photographs were produced in this court as evidence. After the photographs and the scene was processed, the deceased body was moved to Chiromo mortuary. Of course, as is expected, investigations commenced. And it revealed that several people had visited the deceased on that night. Those people became of interest to the investigators. And as that was going on, Walidi, the neighbor of the deceased person, is said to have notified the family members that he had been and was in the deceased house the night before. And he mentioned, and so did Owen, that he too was in the house, but they were in the company of one Joe. It is in evidence that the deceased brother, Kimani, knew of a person by the name of Joe, and he sought to establish from Owen, through a photograph given to him, whether that was the person who was in the deceased house, and Owen's answer was in the affirmative. Mr. Kimani testified that he knew Joe, as they were in college together at Kenya Polytechnic as far back as 2012. And that he knew that Joe was known to the sister of the deceased, and he knew that Joe had a fiancé who was in the media industry, and so he approached Joe for assistance to have the death publicized. It is the evidence of Kimani that when he approached Joe for assistance, Joe told him that he would get no assistance from the media, but opted to assist through his private company to deal with the matter. The investigations advanced. It was discovered that the first accused person had made a report at Langata police station to the effect that he had been involved in a shooting incident. And so the team that was investigating the murder case got an interest in that shooting incident report, and eventually a team from the homicide department, the Directorate of Criminal Investigation, took over the investigations of both the shooting and the murder incident. The investigations in this matter were led by PW 35 Chief Inspector Otieno. It was the evidence of Chief Inspector Otieno that in the course of investigating the shooting incident, they discovered that there were contradictory statements as to how the shooting occurred. With that as it were, back to the murder issue. The first accused person was arrested, subjected to an identification parade. It is the evidence of the prosecution that he was identified by 3 witnesses. Subsequently, the second accused person was also arrested. And according to the prosecution case, she was arrested because 1, she was within the vicinity of the commission of the murder. According to the prosecution, the vehicle that was used in the commission of this offense was hers. According to the prosecution, she aided and abetted the first accused person by providing that vehicle. According to the prosecution evidence, she switched off her phone at the time when the offense was being committed. According to the prosecution case, she gave false information to the police about the shooting incident, and the intention was to divert their attention from investigating the murder charge that will be used in the murder case through the burning of the items that were recovered, believed to have been the items used in the commission of the murder and eventually destroyed. In a nutshell, that was the prosecution case. At the close of the prosecution case, each accused person was placed on their defense after the court found they had a case to answer. The first accused person gave a sworn statement in his defense and testified to the fact that he works as a security consultant, and that on the 19th day of September 2018, he dropped the second accused person at work at 8:05 a.m. and returned home at Royal Park Estate in Langata. It was his evidence that he stayed at home until about 3 o'clock when their house help notified him that there were people from Kenya Power and Lighting who had gone to attend to an issue at the house, and so he went to attend to them, and that was done. It is his evidence that he eventually, excuse me, that he left the house at 4:30 p.m. to a place known as Roadhouse along Dennis Pritt Road, where he arrived at 5 p.m. He met a friend by the name of Jennings, who testified as prosecution witness number 8. According to him, after their conversation, they went looking for fuel for his vehicle, got fuel. He dropped Jennings back to pick his vehicle from where he had left, and he, the first accused person, proceeded to join the second accused person at a club in Westlands described as Club 4040. It is his evidence that they left the club at 4 a.m., drove home and slept. That the following day, which was the 20th day of September 2018, he dropped the second accused person at work and then went to pick her at 8 p.m. After and before they left, a quarrel ensued between them, which spilled to home. And when they got home, the second accused person threw his things out of the house. And as he was extremely drunk, he didn't realize that he had a gun. His gun went off and injured him. That the gun was not his. It belonged to his neighbor by the name of Brian Kasaine speeder, PW17. And so he rushed to Brian's house and told Brian to go and secure the gun. Brian went secured the gun and assisted him to go for treatment. He was taken to Langata Hospital. Langata Hospital referred him to Nairobi West, and eventually he ended up at Kijabe AIC Hospital for admission and treatment. That he was later arrested, taken to his residence. A search conducted, several items picked up, and he was charged. In a nutshell, that was his evidence. As already indicated, the second accused person gave evidence to an unsworn statement. Her evidence was that on 19th day of September, she went to work as usual, worked until about 8 p.m., and as she was leaving work, she was requested to stay on as there was an interview for the former governor of Nairobi County. She stayed there. After the interview ended, she joined others. They went to Q Lounge and eventually ended up at Club 40 at Westlands. That they were joined by the first accused person slightly after midnight, stayed there until 4 a.m. and went home. And that the following day she went to work as usual, and that when she read the news item on the deceased's death, she did so in the ordinary course of her business as a newscaster. And so generally she denied knowledge of the commission of the offense. She denied knowledge of the deceased. She testified she had no motive to kill the deceased and that she was not there, basically advancing the defense of alibi, and invited the court to take and use the statement of PW11 Chelagat, who had testified that they were together in Westlands. Just to play back as one of the testimony and evidence of the first accused person, it was his evidence that he did not know the deceased at all. So that ends a summary of my factual background. Okay, I'm on page 15. Please drink adequate water. I'll probably go to page 115. I'm now taking up the analysis and determination. May I, for the benefit of the councils, because I think we all come to court to give the court evidence and would really want to appreciate that the court analyzed all the evidence. I can assure you I did. I can actually read this judgment for 6 hours without a paper in my hands. Okay. So why am I telling you this? If you do not hear me read out your submissions verbatim, please wait for my judgment. I have, as a general statement, taken into account your submissions. In my understanding at this point, the key question to determine is whether the prosecution has discharged its burden of proof, which is beyond reasonable doubt that each or both accused person murdered the deceased. It is strict law in criminal cases that the burden of proving a crime lies on the prosecution to prove the ingredients of the charge beyond reasonable doubt. This is explicitly set forth in the provisions of Section 107, 108, and 109 of the Evidence Act, which is Cap 80 of our laws of the land. These provisions of law speak to proof of the existence or otherwise of a particular fact in relation to the offense under consideration. The burden remains on the prosecution throughout the trial. The rationale behind the proof of the prosecution case beyond reasonable doubt is based on provisions of Article 50, Sub-Article 2 of the Constitution of Kenya 2020, which stipulates that each person has a right to a fair trial, which includes the right to be presumed innocent until the contrary is proved. There is ample judicial authority underscoring this principle of burden of proof. I'll draw your attention to two cases that are made reference to. A case from the Supreme Court of Nigeria, Bakare versus State, and I'll just read a bit of what the court said in that matter, that proof beyond reasonable doubt stems out of the compelling presumption of innocence inherent in our adversarial system of criminal justice. To displace the presumption, the evidence of the prosecution must prove beyond reasonable doubt that the accused person is guilty of the offense charged. Absolute certainty, however, and please carry with you these words, they may be important later. Absolute certainty is impossible in any human adventure, including administration of justice. Proof beyond reasonable doubt means just what it says, but does admit a high degree of consistence with an equally high degree of probability. Allow me again to draw your attention to the case of United States versus Smith. Long citation, you can pick it. Long quotation from that case, but very important. And this is what the court had to say. The burden is upon the state to prove beyond reasonable doubt that the defendant is guilty of the crime charged. It is a strict and heavy burden. The evidence must overcome doubt concerning the defendant's guilt, but it does not mean the defendant's guilt must be proved beyond all reasonable doubt. A reasonable doubt is a fair, actual, logical doubt based upon reason and common sense. A reasonable doubt may be either from the evidence or lack of it. Reasonable doubt exists when you are not firmly convinced of the defendant's guilt after you weighed and considered all the evidence. A defendant must not be convicted on suspicion or speculation. It is not enough for the state to show that the defendant is probably guilty. On the other hand, there are very few things in this world that we know with absolute certainty. The state does not have to overcome every possible doubt. The state must prove each element of the crime by evidence that firmly convinces each of you and leaves no doubt. The proof must be so convincing that you can rely and act upon it in this matter of the highest importance. If you find there is reasonable doubt that the defendant committed the crime, you must give the defendant the benefit of doubt and find that the defendant is not guilty under the circumstances. Moses Nato Raphael versus Republic. Rain states an important point. Burden of proof lies on the prosecution. But does not takes note of exceptions. A few instances, the law may shift the burden to an accused person. And they quote a celebrated case of Wilmington, which is cited under 1935. Allow me to take a bit of time on these authorities because I'm sure the lawyers understand they're important. It does recognize that although the burden of proof is on the prosecution, as we put it in our world, by every general rule there is an exception. And so, throughout the web of the English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, subject to the qualification involving the defense of insanity and to any statutory exceptions. If at the end of the whole of the case there is reasonable doubt created by evidence, as I've already said, the doubt goes to the benefit of the accused. May I again just draw your attention to Jowie versus Republic. I am now back home. I've been to Nigeria and UK. I've come back home. Criminal Appeal number 96 of 2021. But that quotes our otherwise well-known jurisprudence guru, Lord Denning. Miller versus Ministry of Pension, 1947, All England's Law Reports. What did Lord Denning say? That a degree is well settled. It not reach certainty, but it must carry a high degree of probability. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. I'll read that again. Beyond reasonable doubt does not mean proof beyond a shadow of doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the cause of justice. If the evidence is so strong against a man as to leave only one remote possibility in his favor, it is possible, but not in the least probable, the case is proved beyond reasonable doubt, but nothing short of that will suffice. I have said enough on reasonable doubt. Having said what I have said and set the law as it is, I shall now turn to the charge before this court. It is a charge of murder. Section 203 is read together with Section 204. The pertinent section is 203. I quote it. Any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. The above ingredients of the offense have been settled. The elements, the ingredients of the offense of murder have been settled through various court decisions. I have picked a Court of Appeal decision that sums up the ingredients of the offense of murder. Joseph Githua and Njuguna versus Republic, 2016 EKLR. And this is what the court had to say. Under Section 203 of the Penal Code, any person who of malice aforethought causes death of another by unlawful act is guilty of murder. It is clear from this section that the prosecution must prove beyond reasonable doubt to secure conviction of the offense the following. 1, the death of the deceased. It's important we take note of this. My judgment dwells on these ingredients. The death of the deceased. 2, the cause of that death. And for ease of understanding, in my judgment, I've discussed the death of the deceased and the cause thereof together. The second ingredient is that the appellant committed the unlawful act which caused the death of the deceased. And finally, that the appellant had harbored malice aforethought. So based on the provisions of Section 203 and the authority have cited, I have drawn the ingredients of the offense of murder as follows. You must prove the occurrence and the cause of death. There's need to prove that death was lawful or unlawful. Most likely for the prosecution, they'll be saying it was unlawful. There is need to prove the offense was committed by the accused person. And finally, the prosecution needs to prove malice aforethought. So right away, I move to the first ingredients, the death of the deceased. It is the prosecution case the death occurred. And to prove the death occurred, the prosecution, through the evidence of PW 13, that is the caretaker, the evidence of Stephen Wanjohi, P14, and the evidence of George Kimani, P11, is to the effect that they were the first persons on the morning of 20th of September to go to the deceased apartment and found her body in the bathtub. We are answering, did the death occur? Secondly, we have the evidence of PW2, the scene of crime officer, produced photographs number 27 to 42, showing, among other things, the body of the deceased in the bathtub and after it was removed from the bathtub. Thirdly, we have witnesses who identified this body at the Chiromo mortuary for purposes of postmortem. They included the deceased brother, PW10, the uncle Peter Njenga, Sergeant Maina, and Police Constable Biko, both from Kilimani Police Station. And finally, we have the doctor who performed postmortem, Dr. Njenga, Peter. He confirmed he carried and performed postmortem on the body of the deceased on 24th of September 2018 at Chiromo mortuary. So from that evidence, it is the finding of this court that the prosecution have proved beyond reasonable doubt the first ingredients of the offense of murder, that the death of the deceased occurred. It suffices to know the defense did not dispute the occurrence of the death of the deceased. I now move to the cause of death. May I draw us to the provisions of Section 213 of the Penal Code, which is very long and which I've made a general reference to. And so it provides the circumstances under which the cause of death may be inferred and proved by way of circumstantial or medical evidence. And in that regard, allow me to draw your attention to the case of Benson Gunyi versus Republic and request that you look at it later. In support of the prosecution case as to what caused the death of the deceased, the prosecution called the doctor who performed a post-mortem on the body of the deceased. And this is what the doctor said, that he made an observation. It was a body of a female, aged about 28 years. It was wrapped in a blood-stained wet maroon and white bed cover. Both hands and right leg had henna tattoos and sealing straps. On examining the body externally, he noted that there was an irregular invasive wound, interior neck, measuring 7 by 6 centimeters, with visibly slit trachea and air wave. That there was blood oozing from the nostrils. The body was pale, an indication it was lacking blood. He saw contusions on both wrists and bruises around the wrist of both legs. Internal examination revealed that the air wave had been shot through and through. The trachea had been transected at the level of thyroid glands, and the right carotid artery on the neck and right jugular vein had been severed. The doctor says that means cut through and through, and there was blood oozing from her private parts. So the doctor formed the opinion that the cause of death was exsanguination due to severe neck injury due to sharp force trauma, and that the probable weapon used was a sharp object. So based on this evidence of the doctor, it is the finding of this court that the prosecution have proved that the cause of death of the deceased. Okay. The third element I am addressing is whether that death was lawful or unlawful. Article 26, sub-article 3 of the Constitution of Kenya states that, excuse me, a person shall not be deprived of life intentionally except to the extent authorized by the Constitution or the written law. We all know that if a death sentence is applicable and the court makes an order that you go and suffer death, yes, you are entitled to your life, but once the court makes a finding, then you fall under this provision as an exception. So the question one would be asking is, now that we have established the death occurred, and what caused it, then was that death lawful? In addition to say Article 26, may I draw your attention to the case of Gusambizi Wesonga versus Republic 1948, where the court said this: every homicide is presumed to be unlawful except where circumstances make it excusable or where it has been authorized by the law. For homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or defense of property. Pursuant to these provisions and in my own understanding, I find that excusable homicides are killings which result from accident or inadvertence or done up by a person who lacks capacity to commit an offense, such as a young child or a person who is legally insane or in any reasonable defense to self or property. In the instant matter, Dr. Njenga did not testify to any circumstances that would amount to excusable homicide. In cross-examination of the doctor by the defense counsel, he stated that there was no evidence of strangulation, nor a gun or bullet wound, and there was nothing unusual in the pancreas, indicating that the blood that was oozing from the nostrils was because the throat was slit at the level of the thyroid glands, and ratified that the wound would not have been inflicted after the death, because a person does not bleed after death, as it is the heart that causes the bleeding. Pursuant to the evidence of this doctor. It is the finding of this court that the deceased did not die of an accidental or natural cause. The death was not accidental, it was not an unnatural death. Therefore, this is a clear case of homicide that falls outside the excusable homicides. And so, the finding of this court that the prosecution have proved that the death was unlawful. We are still on our ingredients of the charge. And so the next issue to determine is whether each or both of the accused persons are the ones who caused the death of the deceased. And then finally we'll be answering a question: if they did they have malice aforethought? Because you can cause a death, but you didn't have malice aforethought, and of course that may be manslaughter. We are dealing with death. So they need not just to prove that they committed the offense, but there was malice aforethought. I have chosen to take the path of looking at the evidence that relates to the first accused first in relation to that issue, and then go to the evidence relating to the second accused person for ease of understanding and flow of the judgment. And so right now I'm analyzing the evidence the prosecution have adduced in answer to the question as to whether the first accused person caused the death or killed, bluntly put, the deceased. Under this particular issue, I have discussed several items just for understanding of the parties. And let me just mention some of the items that fall under this. There is the issue of identification parade. There is the issue of the cloth which the accused person was wearing. There is the issue of a stolen ID card. There is the issue of destruction of evidence. There is the issue of the gun. And so I will try and flow the issues in what I believe is a chronological manner, again for ease of understanding. Now, if I may fast track us, I have, in answering this question, which is a very critical question and very critical part of the judgment, summarized the prosecution's submissions, summarized the victim's family submission, and summarized the first accused submissions. And Professor Nando treated me to good substance, not good in the sense that none of the other people's substance, but in terms of volume. So a bit of this judgment, which I think runs into about 30 pages or 35 pages, is really a summary of what the parties submitted, okay? But I would like to read it out in brief for us to move. And so, the prosecution, of course, advanced their case that the first accused person killed the deceased. And they did that by inviting this court to look at the conduct of the first accused person before, during, and after the murder. And inviting this court to do that, the court was invited to note the following: that one, before the murder, it is the prosecution case that the first accused person stole the ID card of Dominic Becerra Harun and went to use it to access the residence and the premises where the deceased was staying. That is the submission of the prosecution. It is the submission of the prosecution that the first accused person had extra cloth, changed into those cloths, went to the deceased house, committed the murder, changed out of those clothes, and does it. It is the prosecution case that the first accused person armed himself with a gun to the deceased house to use it to subdue, to intimidate, to coerce her to submit before the murder or in the course of the murder. It is the submission of the prosecution case that after the accused person, that is the first accused person, had committed the offense, he went and destroyed the cloth, which would have been used as evidence in this case. It is the prosecution case. He then shot himself to divert the attention of the investigators from investigating the murder charge to investigating a shooting incident. The family of the deceased concurs and associates themselves with the prosecution case and invites this court to note that the evidence by the first accused person that he did not know the deceased is insincere. And they draw the court's attention to the fact that there is call data that speaks to the contrary. And the family of the victim submitted to this court that it should take cognizance of the fact that motive is irrelevant for purposes of proof of the offense of murder. What did the first accused submit on? The first accused persons have submitted that the description given by the prosecution witnesses on the clothes that the first accused was wearing is generic in the sense that those clothes did not have any marks that would identify them specifically out of any other clothes of the same kind. The first accused person has submitted that there was a lot of contradictions in the prosecution witnesses' testimonies. I have analyzed what they are inviting this court to consider as contradictions, and they are as follows. One, that there are contradictions on the time when Haron entered the deceased house and left. And that saying those contradictions arise from the record held by the protected witness number 3, the guard at the gate, that shows that Haron entered the deceased house at 23:21 and left at 23:31, and therefore that suspected killer was in the deceased house for only 10 minutes. And they are submitting, is it possible to commit a murder in 10 minutes of this kind? They have submitted that the person whom the court is being invited to deem as the first accused person and who has been identified as Haron is not the first accused person. That the prosecution have failed to show the nexus between Haron and the first accused person. They have invited this court to look at the contradictions as they relate to the evidence of the witness number 8, Janice, that the first accused person had a bag in which he carried a white counsel when all other witnesses do not speak to a bag. They have invited this court to consider that the accused person has said he didn't know the deceased, and therefore there is no way he would have even known that he was coming from South Sudan. They have told this court to consider that when you look at the ID card or Becerra and you look at the accused person, there's no relationship. They have invited this court to take cognizance. May I request that you probably stop there for now? Thank you very much. I realize that I need the attention of the council, but they need water, so I hope you have water.
Thank you.
This court has been invited by the first accused person in his submissions to take note of the fact that there is a message that was sent to PW16 Kaka from the phone of the deceased person saying, "Kuja unisaidie kulala." And that if that message got to the deceased Sudanese boyfriend, he would have gotten infuriated, he would have gotten annoyed, and probably would commit the murder. This court has been invited to consider that the forensic evidence showed that other than whatever evidence the prosecution had brought, there were two other unknown male whose DNA was found on the strappings that were used to tie the deceased. And so the argument by the first accused person is that it is these two other male persons, they are known, that must have committed the crime. This court, I said the first defendants treated me to quite lengthy submissions, and I took all of them into consideration. This court has been invited to note that the allegations by Brian Kasaine Spira that he was called by the first accused person at 2 a.m., asked for paraffin to go and burn some items is not true. This court has been invited by the first accused person to find that the shot that the prosecution produced in this court, having blood stains of the deceased and which has been attributed and said to belong to the first accused person, is not the shot which the police collected from the first accused house. That if the prosecution needed to prove beyond reasonable doubt that shot is the same shot they collected, they should have brought a photograph thereof. This court has been invited by the first accused person to make a finding that the identification parade process was flawed. This court has been invited by the first accused person to find that there was an intention by the investigators to fix the first accused person, and that is evidenced by capture of a wrong vehicle somewhere in Karioko to tie the evidence of a witness who said that the first accused person told him he stays in his sleep. This court has been invited by the first accused person to make a finding that the evidence by Jennings PW8 that he drove the second accused person's vehicle is a lie, and that he had his own vehicle and at no time did he drive the second accused person's vehicle that was with the first accused. The court has been invited to make a finding that there was no blood stain at all on the shot that the deceased had, and which was, the first accused had, and which was collected from his house. The court has been invited to consider that the investigating officer did not investigate satisfactorily or adequately whether the deceased Sudanese boyfriend was in Kenya and could be a suspect. The court has been invited to note that other persons who were in the deceased house on the material night were never subjected to an identification parade. And so, in a nutshell, the court is being invited to make a finding that the prosecution have not discharged their burden of proving the case against the first accused person beyond reasonable doubt. And he should be given the benefit thereof. That this court do dismiss the case against him for lack of merit. So, having considered the evidence that I've spoken to and the submissions, I've raised the following issues for determination. 1, whether the first accused person knew the deceased prior to her death. Secondly, whether the first accused person stole and used the stolen identity card to access the Muria Gardens where the deceased was staying. Thirdly, whether the clothes that the first accused person was wearing on 19th of September 2018 implicates him in the commission of the offense. Fourth, whether the accused person was in the deceased house on 19th of September 2018, and whether he was the last person to be seen with the deceased. The fifth item, question. Whether the first accused person had a gun on the particular night and used it to subdue the deceased. The next issue I'll be looking at is whether the first accused person was positively identified on the identification parade. And lastly, but of course not the least but very important, a recap of whether then the prosecution have given this court adequate evidence to make a finding that the first accused murdered the deceased. So let's take the first issue. And the question is, did the first accused person know the deceased prior to her death? And this question has arisen because the evidence of the first accused person is, I did not know the deceased at all prior to her death. So let's analyze the evidence together. I have considered the prosecution evidence and the evidence of PW10, George Kimani, the brother of the deceased, is that he is known to the accused person because they were together at Kenya Polytechnic. As far back as, I think, 2002, they were in the same class, taking the same course in hotel and beverage management. It is the evidence of that witness, please mark the date, on 31st of August 2018, he was with the first accused person in the house of the deceased. The death hearing was on allegedly unknown time, but it's said to be 19th of September. But I am saying, and I said, please mark the date. This witness, the brother of the deceased, says, prior to the death of my sister, on 31st of August 2018, I, my girlfriend, the first accused, and the deceased were in the deceased's house. The Moria Gardens, same apartment. And that the sister, the deceased, mentioned to him that she was communicating with the first accused on Instagram. That on the material night, the first accused person and him slept on the sofa set, otherwise known as the couch, whereas the deceased and the brother's girlfriend slept. And I'm not saying this for no reason. Everything I say has a reason. Slept on the deceased bed. It is also the evidence of George Kimani. On 19th of September, the deceased sent him a screenshot of a conversation between her and the first accused. And that conversation was to this effect. The first accused was telling the deceased that when he returns from Mombasa, he would go and see George Kimani, that is the deceased brother, for a drink. And that the deceased was telling the first accused person, don't spoil my brother. 19th of September. My observation from the evidence is that this evidence of George Kimani, that on 31st of August 2018, he was in the deceased house with the first accused person, was not disputed through cross-examination of the witness by the first accused person. And I will tell you why. This was the nature of cross-examination by the first accused person. I quote, the deceased was communicating with Jowie, but she didn't describe how they were. I believe they were friends. There is a night we spent with the first accused in the house of the deceased. We were all happy. I slept on the couch. I woke up in the morning. The first accused person had already gone. When I woke up, I was not very drunk. I wouldn't know what the first accused person did with my sister when I was asleep. I don't know whether he was another man in my sister's life. If he was, I would have known. I did not know Kako. And my analysis of this cross-examination does not lead to an accused person denying that I have never, I don't know the deceased. Further to this evidence, it is the prosecution case that there was a video retrieved from the first accused cell phone, which was allegedly recorded by the first accused person, which shows that he was in the deceased house prior to her death. I did not have the benefit of that video. I must make it clear. But more importantly, and this evidence to the court was very important. Why am I saying it was very important? Because the evidence of George Kimani is evidence from a relative of the deceased. I treated the next evidence that I'm going to speak to as independent evidence to the question as to whether the first accused person knew the deceased prior to her death. This is the evidence of number 70110, Corporal Jonathan Limo, who testified as PW33. This is an officer tied to Safaricom Law Enforcement. He's a data analyst, and he said in his evidence that he analyzed data from a telephone number 0727 001675, registered in the name of the first accused person, Joseph Irungu Kuria. He also analyzed data from 2 cell phone numbers, 0727, 0704 170422, 0715 775856. Both of them were registered in the name of the deceased, Monica Nyawira Kimani. It is the evidence of this witness that on 1st of September 2018, the number of the first accused person called the number of the deceased. And that call was made at DOD Langata, and it was an outgoing call. Based therefore on the evidence of George Kimani and the data analyst PW3 by the first accused person that he did not know the deceased prior to her death is untenable, it is insincere, and it is the finding of this court that the first accused person was known is whether the first accused person stole an identity card of Dominic Bisera and used it to access Ramuria Gardens, where the murder took place, on the fateful night. I will be probably returning back to this evidence. You will get to know why, but let me speak to it now. Excuse me. Dominic Bisera Harun testified in this court. And his evidence was to the effect that on 17th of September 2018, he went to Royal Park Estate in Langata to look for casual work. The requirement at the main gate was that you leave your identity card at the gate. And so he left his ID card at the gate. And he was supposed to collect it in the evening after work. When he came to collect his ID card, he did not find it. The following day he went, he did not find his ID card. I am speaking to the events of 17th September 2018. And so he left his contacts written in the book with the guards, the occurrence book, contacts, Dominic, telephone number, and said, turn into a bit of Kiswahili, mukipata hii kipande changu, tafadhali mnijulishe. I have had the benefit of that record. It is his evidence that he never got his ID at all. I have had the evidence of the witness who came from the Registrar of Persons, who has confirmed to this court that Dominic Bisera Harun eventually got a duplicate ID in the year 2019. There is evidence from witnesses at Royal Park that is true, Dominic lost his ID. There is evidence from Protected Witness 3A to the effect that the person who went to the deceased house on 19th of September 2018 produced an ID in the name of Dominic Bisera Harun. This witness identifies the first accused person on the parade as the Dominic Becerra Harun. I come to the parade. And so, at this stage, I find adequate evidence that the ID of Dominic Becerra Harun was stolen at Royal Park Estate in Langata on 17th of September, 2 days before 19th of September, when the offense was committed. I have made an observation that this ID was stolen from Royal Park Estate Langata, and it happens that the two accused persons were residing at Royal Estate Langata. As to whether the first accused person used this ID to access the Muria Gardens and commit a murder, hold it. The next question and issue I'm going to address is whether the cloth which the first accused person was wearing on the material date implicates him in the offense. I have taken a route of flow from where he started. And of course, we all start by dressing in our houses. Hopefully. I'm not saying anything. So the first evidence as to the cloth which the first accused person wore was the evidence of Pamela, the house help, PW 15. She says that when the first accused person left the house on the 19th of September 2018, he was wearing a white shirt with patterns, a maroon cap or cap, and brown shorts. Now, the prosecution produced a brown shirt marked as exhibit number 9 and a maroon cap marked as prosecution exhibit number 4. And they were shown to the witness, and she says, yes, they look like what he was wearing. And then she's cross-examined by the first accused defense counsel, and I picked an extract from her answer in cross-examination, and this is what she said. Jowie left at 4 p.m. in brown shirt, maroon cap, and a small bag. This is not in my statement. This shirt is the one produced in court. End of quote. So that's Pamela, what the first accused person was wearing when he left the house. When the first accused person left the house, the next person he met was a gentleman known as Jennings, who was given evidence as prosecution witness number 8. Let's see what Jennings said about them. Jennings confirms that he met the first accused person at Rose's house, and in relation to the clothes he was wearing, he says this. The first accused person was wearing a t-shirt, a maroon cap, and a brown short. Again, he's shown exhibit number 9. He says, yes, this shirt looks like what he was wearing. And he's shown exhibit number 4, and he says, this cap looks like what he was wearing. Jennings goes beyond these 3 items, the t-shirt, the short, and the cap, and says this, that he left Roadhouse where he was meeting with the first accused person, and that the first accused person requested him to drive his car, and of course then he went to the passenger seat. He took a bag which he had. He removed a white kanzu from the bag and a 4th item or cloth white kanzu and put on top of his cloth. And then he left to go where he was going. So the second person who speaks to the cloth which the first accused person was wearing is Jennings. And he speaks to a t-shirt, he speaks to a brown shirt, and he speaks to a kanzu. The third person who spoke to the cloth which the first accused person was wearing is PW11, Chelagat. Chelagat tells the court that she knew the first accused person because she is a friend to the second accused person. And Chelagat says that on that particular date, the 19th of September, she went to Roadhouse. Remember, Roadhouse is where the first accused person and Jennings were meeting. She went to Roadhouse in the... They found the place was packed, and because she knew the first accused person, she and Juju joined the first accused person and his friend Jennings on their table. They had drinks and food, and when she's asked the clothes the first accused person was wearing, she says the first accused person was wearing white shoes, t-shirt with some prints at the front, a brown khaki shirt, and a maroon cap. Again, she's shown the white shirt, the brown shirt. Exhibit number 9, she says it looks like it. She's shown the cap, she says yes, it looks like it. She is cross-examined, an extract from her evidence I took. She says, I described the shirt as brownish. There are back pockets. The shirt had side pockets. At 40-40, he was wearing the same shirt. The fourth witness who speaks to the clothes the accused was wearing is the guard at Lemuria Gardens. And I'm hoping the manner in which I'm flowing my decision is helping us to move with the movements of the first accused. From the house, road, house, and then allegedly we'll come to see whether it's an allegation or it's been proved. Lemuria Gardens. Now, this witness says this, that the person who came to the deceased house identified himself as Dominic Becerra, Harun, came in a taxi and he was wearing a white kanzu. The next witness who speaks to the cloth which the first accused person was wearing is PW7, Lee Owen. Lee Owen says that when he went to the deceased house, he found the first accused person was introduced to him as Joe, and he was wearing a pure Muslim white kanzu. Ash gray coat, red stroke maroon cap. And he says this, that in fact, the deceased person made a comment on the white kanzu which the first accused was wearing. And she said, I've translated it into English but in Kiswahili. Kwa nini huyu leo amevaa kanzu? Kwa kawaida huwa havai kanzu. That the deceased remarked, why is the first accused person wearing a kanzu today? He usually does not wear a kanzu. Now, what comes out of the evidence of these witnesses? About 5 of them. 1, that all of them, Pamela who was at the house, Jennings who was at Roadhouse, Chelagat who was at Roadhouse, 3 of them speak to the same 3. Then we have the second set of witnesses, but there is a bridge, which I'll bring. Jennings, the guard at Lemuria, and Owen speak to a white kanzu. The question is this. Why is there divergence? How come Pamela does not speak of a white counsel? How come Chalaga does not speak of a white counsel? And the answer was not far from the analysis of the evidence. The answer is when the first accused person is said to have left the house, he was not dressed in a counsel. So this counsel is, according to the evidence of Jennings, was worn just before he went to the house of the deceased. And so anybody who met him before he went to the house of the deceased would not have seen the counsel. Do these clothes implicate him in the commission of the offense? Hold your horse. Three other things on this cloth. One, were these clothes recovered? If so, where? The evidence reveals that the short and the maroon cap were recovered and they were produced in this court. The police have brought an inventory that the first accused person is supposed to have signed, acknowledging the clothes were found in the house where he was staying. Those clothes have been shown to the witnesses. They have identified them. But what was not brought to this court was the white counsel. And how do the prosecution deal with the absence of the white counsel? They bring evidence to the effect that during their investigations they discovered that there were items which the first accused person burnt. And among those items, they recovered the remnants. There was a white piece of material which they believe was the counsel that was not completely burnt. The court had the benefit of seeing the white counsel piece of material. My observation as a court, it was evident that piece of material was stitched. You can see the running of the machine. So it's not like somebody just cut a piece of material and there it was, there were stitches. Which in the logical conclusion is that it must have been a piece of cloth stitched for wearing. Two, and I'm now getting into the submissions that were brought by the parties. The first accused persons heavily submits on the fact that the shot which has been produced in this court as Prosecution Exhibit 9 was not the shot collected from his house. And you will understand why that evidence is heavily fought, because that shot is supposed to be having blood stains of the deceased, critical. But the evidence is this, that shot, when it was recovered, it was entered in an inventory and the accused signed the inventory. The argument of the first accused person is that this shot in this court is faded yellowish. I had the benefit of seeing that shot. There is nothing faded yellowish. It is a khaki brown shot. This court was told khaki is not a color. It is a mixture of nylon and others. The color is not khaki, the color is brown. I had the benefit of looking at that white piece. It's a relatively big piece, and one cannot rule out that it may and was the counsel. But I did also take cognizance of one important thing which none of the parties here submitted to. But I am expected as a judge, as a court, to comb through all the evidence. And I did. There was a lot of contestation on the shot, but it was very clear. No one disputed that the first accused person is supposed and was wearing a maroon cap. So a lot of questions was on white council, and the brown short. No question on the maroon cap. Yet, this maroon cap knits and joins right from the house where the first accused left. The house help says he wore a maroon cap. Jenny's at Roadhouse, he wore a maroon cap. You go to Chelagat, he had a maroon cap. You go to the guard at Ramuria, Haron had a maroon cap. You go to the witnesses who are in that house, he had a maroon cap. A maroon cap has been produced in this court. Does the accused person say it's not mine? No evidence to that effect. I have also considered the submissions by the first accused counsel that the clothes that have been brought to this court are generally ordinary clothes that you can't get in the market, and that they did not have any specific identifiable marks that would pin the first accused. And my simple argument is this. Really, when clothes are manufactured in the factory, they manufacture them in bulk. The only way I will distinguish the other day I saw a newscaster wearing I'll not tell you who, a blouse like mine. And I'm sure any one of us can speak to the fact that we wear clothes that are manufactured in the same place, isn't it? The only difference is the size. So if you want to say that my clothes have an identifiable mark, then I should put that mark for that purpose. Otherwise, clothes are just clothes. So the fact that these clothes did not have any marks that would say this cloth only belonged to so and so, for me was not a tenable argument. But my findings on that is that there is corroborative evidence as to the cloth which the first accused person was wearing on the material date. Please allow me to move to the next issue. In that reading, I've done away with quite a bit of material, so you will not wait for too long. Summarized quite a bit of it. And so the next question is whether the accused was in the first accused was in the deceased house on the material date, and whether he was the last person to be seen with the deceased. Now, considering the evidence of PW7, Lee Owen, his evidence is that the first accused person was in the deceased house. Waridi did not testify, and nothing much can follow on his evidence if he has not been tested on it. But the strongest argument the accused person is advancing is that, look, there were these two other male persons. First of all, there were other people, the Kinawaridis, the Lee Owens, the Kakas. Why were they not also investigated? But he advances another argument. The strappings that were used to tie the deceased, the evidence of the government analyst is that it revealed DNA of two unknown males. These are the people who were in that house, and that Dominic Harron. Allow me to make my observation. But before I do that, back to Lee Owen. You know, Lee Owen is the witness who says, I was with the first accused person. And I needed to find out Why is Lee Owen? How can the court admit or disallow, or what is the weight that this court needs to put on the evidence of Lee Owen as the one who saw the accused in the deceased house? And this is what Owen said. That first of all, he stayed with the first accused person in the deceased house for over 1 hour. That was his evidence. Secondly, the first accused person was using coded language. Thirdly, he had a beard. And fourthly, he had brownish eyes. Then he says, in their conversation with the first accused person on that day, these are the words the first accused person said, and I'll quote, that in their conversation with the first accused person in the deceased house on that day, these are the words that the first accused person said. And I've quoted them verbatim. In reference to another country where they account for everybody, not like in Kenya, where you can come and do something and just disappear, and someone can impersonate, since we don't have a database. In reference to another country where they account for everybody, in Kenya you can come, do something, just disappear, or impersonate somebody, since we do not have a database. And then, of course, Owen says he identified him on the parade. I'll come to the parade. Other than the evidence of Owen, I sought to find out whether there is any other evidence that would place the accused person maybe in the deceased house. And I came across the evidence of PW25, Chief Inspector Frederick Ngahu. Attached to the Directorate of Integrated Command and Control Center, and he brought records of the movement of vehicle KCA E03E, the second accused vehicle which the first accused person was using, had indicated, without me having to read in details, that this vehicle was within the subject time and the set time within the Dennis Pritt area. And that is within the vicinity of the commission of the offense. And so, it is the finding of this court that there is evidence the first accused person was within the vicinity of Dennis Pritt area, the vicinity of the commission of the offense, and that corroborates the evidence of Lee Owen of his presence in the house of the deceased. But I have looked at his submissions about the two, male and the unknown. And I took time to think about this. And this is my findings and my observation. That we are talking about DNA on straps. And I'll repeat that. We are talking about DNA being found of male on the straps. We are not talking about DNA on the body of the deceased. Hear me out. Straps have taken judicial notice of the fact that there are items that can be purchased from a departmental store. And they can be handled by more than one person. The seller, the buyer, and the end user. And therefore, the possibility of DNA of more than one person being found on these straps is not far-fetched. It's not unimaginable. If we are saying that this DNA was on the body of the deceased, it would put beyond reasonable doubt that those people were in that house and had contact with the deceased. In any case, may I take all of us back to the particulars of the charge? They say, jointly charged with others not before the court. I say no more. But finally, before I move out of that area, the question that you must ask ourselves is, does the fact that there may have been other people who are still at large exonerate the first accused person from blame? My answer was in the negative. Was the first accused person the last person to be seen with the deceased? The doctrine of last seen was discussed in the case of Kimani versus Republic, where the Court of Appeal said this, and I will read it because it's important. The doctrine of last seen alive is based on circumstantial evidence where the law prescribes that the person last seen with the deceased before their death was responsible for his or her death, and the accused is expected to provide an explanation as to what happened. In the Nigerian case of Achi versus Tet, 1993, the court relied on the case of Eastman versus Tet to discuss the doctrine of last seen. And this is what the court said, and I quote, "In the case of culpable homicide, as is in the present one, where the doctrine of last seen has been applied, the law presumes that the person last seen with the deceased before the death was responsible for his death, and the accused is expected to provide an explanation of what happened." The last seen doctrine stands as negation. I will repeat again. The doctrine of last seen stands as a negation and an exception to the doctrine of presumption of innocence. It is therefore tried law that where a victim was last seen by the accused and is found dead, the death of the victim will be presumed, and it will be presumed that the last person he was last seen with is responsible for his death. Therefore, if the first accused person is the one who was last seen with the deceased herein, as testified by Lee Owen, then the first accused person will have the burden to explain what happened to the deceased. Please have a look at the case of Achbong versus Tet, 2006, LCN. You'll find it in my judgment. It is the finding of this court that the first accused person was in the deceased house on the material date, and he was the last person to be seen with the deceased. The evidence of the protected witness is that Harun, whom he identified on the parade as the first accused person, left that house at 23, that's about 11, and no one else went to that house. It is the evidence of this witness the deceased Sudanese boyfriend was not in Kenya. And there is evidence that this deceased person was supposed to be traveling the following day to go to Dubai to meet their Sudanese boyfriend on business and holiday. The next issue I'm considering at this point is whether the first accused person had a gun on the material date and whether he used it to subdue the deceased. May I have a little more water? The evidence of Brian Kasaine Spira, corroborated by the evidence of no other person than the first accused person himself is that by 19th of September 2018, the first accused person was in possession of a gun. That gun belongs to Brian Kasaine Spira. And so, it is undisputed that on 19th of September, the first accused person was in possession of a gun belonging to Kasaine, PW17. In fact, Kasaine testified that the first accused person had earlier on borrowed this gun to go on what he said a refresher training, returned it, and then he borrowed it again. And according to Kasaine, and this is important, he was supposed to return that gun after 2 days, but he did it. And so, by 19th September, he had a gun. That corroborates the evidence of Jennings that when they left Roadhouse, the first accused person opened the dashboard of the car and removed the gun after putting a white council on top of his cloth and picked a taxi and went where he was going. And so the question is this: if he was armed with a gun and the gun was not used to kill the deceased, what was it for? I am in concurrence with the submissions by the prosecution that the gun was intended and used for the purposes of subduing the deceased. I'll quickly move to the identification parade. The identification parade was conducted by Chief Inspector Arama. Again, I'm fast tracking, so I'll not go through the rules of a parade. There were witnesses when I looked at the identification parade, and critically so, I noticed the following. One, the identification parade listed 4 witnesses who I do not understand how, but anyway, is there, included the IO, investigating officer. But the investigating officer then was not given an opportunity to go to the parade, but he's indicated as a witness. As I told you, I looked at age and everything that I needed to look at. And the identification parade form has a provision where a suspect is supposed to indicate whether he or she is satisfied in the manner in which the ID parade was conducted. According to the Inspector Araman, who testified as PW28, the first accused person was satisfied that the parade was well conducted. However, it is notable that the first accused person did not sign on that form where he was supposed to sign to confirm that he was satisfied with the parade. Secondly, it is in evidence that PW7, and he admitted Owen, before he went to the identification parade, he had seen the photograph of the first accused person. And so that then must have aided and abetted him to quickly pick up the first accused person from the parade. Thirdly, whereas the officer who conducted this parade, who is Inspector Araman, says that the first accused person was not in a sling, contrary evidence has been given by the prosecution witnesses, including the protected witness. And so, the contradictions can only go to the benefit of the first accused person. And in just emphasizing on the need to conduct a proper identification parade. And for the benefit of the office of the DPP, join me in the words of the court in David Mwitawanja and Others versus Republic. Quite good read on identification parade. And this is what the court said. The purpose for and the manner in which identification parades ought to be conducted have been a subject of many decisions of this court over the years. And it is worrying that officers who are charged with the task of criminal investigation do not appear to get it right. As long as 1936, I don't know whether anyone of us was there, the predecessor of this court emphasized the value of identification as evidence and would depreciate considerably unless an identification parade was held with scrupulous fairness and in accordance with the instructions contained in the police force standing orders. They made reference to the case of Ara versus Mango. And so, the court says this: it is not difficult to arrange a well-conducted parade. The orders are clear. If properly conducted, especially with an independent person looking after the interests of the suspect, the resulting evidence is of great value. But if the parade is badly conducted and the complainant identifies a suspect, the complainant will hardly be able to give reliable evidence of identification in court. Whether that is possible depends on clear evidence of identification. I will not finish the quote. It is the finding of this court that the manner in which the parade was conducted was fraud, and therefore this court cannot find the first accused person guilty of the offense he's been charged with based purely on the evidence of the identification parade per se. The last question is whether this first accused person committed the offense. And I'll pick on issues I raised and that I've not dealt with, so I'll not repeat what I've already dealt with. The first argument of the first accused person is that he can't have committed an offense in 10 minutes, and that is what I want to address now. And that brings in the issue of contradictions on the time Haron entered and exited from the house of the deceased. It is not in dispute that the entry in the occurrence book at Ramuria Gardens indicates that Haron entered the premises at 23:21 and left at 23:31. 10 minutes. That is not in dispute. And the prosecution explanation to the same is that the entry in relation to what time Haron entered the house is erroneous. That is an error. So I took a journey. I'll tell you the journey I took. My journey started with Jennings. Jennings states that they left Roadhouse with the first accused person at 8 p.m. Right? He goes on to state that he then went to a petrol station after the changing of clothes. I've spoken to that, where the first accused person left him waiting with instructions that if the second accused person needed the vehicle, please give it to her, and took a taxi. According to Jennings, by the time they were parting with the first accused person, it was 8:30 p.m. Then we come to the evidence of Lee Owen, who then says, When he arrived in the deceased house at 9, the first accused person was there. Now look at this evidence. Lee Owen says, in fact he says, I entered when the 9 o'clock news were on. And the entrance is saying he entered 23. So let's just continue this journey. They leave Roadhouse at 8, they part at 8:30, and by 9, according to Owen, he's in the deceased house. Then according to Owen, he leaves the first accused in the deceased house. But even departure from the first accused house does not seem to an issue. So the question I've posed for all of us to ask and answer is, if this first accused person left Jennings at 8:30, and by 9 he was in the deceased house, is it possible then the entry that shows he entered at 11 o'clock was an error? The evidence of the timings corroborates a finding that that 23:21 was an error because it does not tie with the movements and the evidence of the witnesses. And so for me, my finding was the argument that I couldn't kill in 10 minutes is not tenable. And I pose the question, if indeed the first accused person, before I even pose that question, I have made an observation that this court visited the scene. This court had the benefit appreciating the distance from Roadhouse to where the deceased was staying. Less than 15 minutes walk. And so if really indeed this first accused person left Jennings at 8:30, he would not have taken more than 15 minutes to be in the deceased house. And that corroborates the evidence of Jennings. By 9 o'clock he was in the deceased house. And so my conclusion is the argument about 10 minutes, not tenable. Now, the forensic evidence. Evidence has been produced in this court that the shot which was collected from the house of the first and the second accused had blood stains. Subjected to forensic exercise, it is the evidence of the prosecution that the blood on that shot was the deceased's blood. Lots of issues arose on that shot. Is it the shot that was collected from the accused house? The accused says no. I ask myself as a court, so are we then saying the police went and bought a shot? Are we saying the police substituted? If they did, where did they find the blood of the deceased to put? Then the accused person advances a further argument. Surely, if there was blood, it should have been seen. I go back to the evidence of the analyst, and he says, and I quote, I think, if I can get it. Yes, here we go, my paragraph 212, my judgment. In cross-examination by the first accused, the analyst stated that the blood stain on the shot was a small spot on the front. A small spot. So one asks, if I were to pick something, was it then generally visible that the scene visiting officer who took a photograph of it, the people who were collecting it would have said, oh, this one has blood. He said it was a small spot. Then there was a question on the storage and the chain of handling. And this is what the witness said, that all XBs are kept in high security cabinet, and this was kept in the high security cabinet marked JKZN. Okay? And in my finding, and it is the finding of this court, no reason has been advanced why the investigating officers would have done away with the shot which they collected from the accused house, find a different shot, subjected to forensic examination, and is found to have the deceased blood. It is my finding that this shot, which was taken to the garment analyst for forensic examination is the same shot which Pamela, the house help, has identified, is the same shot which Jennings, who was at Roadhouse with the accused person, has identified, is the same shot Chelagat, who was with the accused on that day, has identified, is the same shot which is entered in the inventory. At this point, I want to go to the evidence adduced against the second accused person. I don't need to replay what the state and the prosecution said. I've already spoken to it. But I want to bring in the evidence of the second accused person and the submissions. It is her evidence and the submission is that I did not know the deceased. It is her evidence and the submission that I had no reason to kill her. In fact, she says in her submissions, if I knew, leave alone killing, that there was a plan to kill her, the conscience of my banks would not allow me to keep quiet. I would report. She says in her submissions, yes, my phone went off, but says, my phone going off is not commission of a crime. And it was not switched off because I was committing a murder. She says in her evidence and submissions, I gave the first accused persons the vehicle. Yes, it was my vehicle, but I have no control over it when he has it. She says in her evidence, no forensic, no data, no eyewitness places me at the deceased house on the material date. She says in her evidence, the people who visited the deceased were of male gender. I'm of a female gender. And no one has said there was a lady who visited the deceased on the material date. She says I've explained throughout, where I was throughout, from the time I reported to work, to the time I joined the interview of the former governor, to the time we went to Q launch, and then went to Fort 40, to the time I went home. It was the duty of the prosecution to displace my alibi. They have not. And she says, if they're asking this court to convict me for aiding and abetting or an accessory after the fact, there's no evidence I did. And if there is any evidence of anything I did, it has nothing to do with the murder. It could have something to do with the shooting incident. And tells and analyzes and crushes and says, the murder was on 19th, the shooting incident was on 20th. The murder was by a sharp object, the shooting was by a gun, excuse me. And so they are not related. I am not accessory after the fact. I will not read for you is an accessory after the fact. I will not read for you what the sections on aiding and abetting. You will read it for your own benefit when we come to copy of my judgment. As I read, I say a few errors, we will have them corrected. And so for her, the sum total of evidence adduced, either through oral or documented evidence, does not show that she was involved in the murder in any way. she says again, I did not witness the burning of any cloth, and then goes on to say, if anything is the case anyway, the cloth were burnt in a public place, and the investigating officer did not establish whose place it was. Then finally says this, my relationship with the first accused person, and she says, then, my relationship with the first accused person then was that of cohabitation and aiding him to get treatment after he was shot. It's a constitutional right under Article 43. If anything is the case, you can't take a gunshot wound lightly. She says, by any stretch of imagination. She then crowns her submissions by coming to the doctrine of last sin and says, if there is anyone to be asked as to what happened to the deceased person, it's the people who are last seen with her, who are Waridi, Kaka, Owen, and the first accused. Let's look at the evidence. The defense by the second accused person is an alibi defense. The law is settled. One, it must be raised at the earliest, and two, it is the business of the prosecution to displace it. So when the accused person says, I woke up in the morning, I did 1, 2, 3, and removes themselves completely from the commission of the offense, it is the prosecution to say, no, you did, what you are saying is not true, you are. And let me tell you why that is the law. Please join me with the case of Kiare versus Republic in 1984. This is what the court said. An alibi raises a specific defense. And an accused person who puts an alibi as an answer to a charge does not in law thereby assume any burden of proving that answer, and is sufficient if an alibi introduces into the mind of a court doubt that is not unreasonable. All right? But it suffices to note that relying on an alibi defense, the entirety of the prosecution evidence must be considered, either direct or circumstantial, so that the court is appraised to establish whether that accused person was elsewhere and not at the scene of crime. Further, the conduct of the accused and the decision to raise an alibi during the defense hearing case, if that be the case, should not escape scrutiny of the court. Adedeji versus State, failure by the police to investigate and check liability of alibi would raise reasonable doubt in the mind of a tribunal and lead to the quashing of a conviction imposed. Ricky versus State, Free State High Court, the acceptance of the evidence on behalf of the state cannot by itself be sufficient for rejecting alibi evidence. Something more is required. You can read more on that. My last few pages will be dealing with the conclusion, but I want kuteka hatua. Because at this point I posed a question, was the second accused person involved in the commission of this offense? I said, hold on. I have then moved to discuss an issue that has played in this matter and has been identified as distinct from the matter before the court, and that is the gun shooting incident. So let's move to the gun shooting incident. By an OB number 79 of 21st of September 2018, produced in this court as prosecution exhibit number 33, the first accused person reported at Langata police station that while he was going home, Royal Park Estate, he was shot by thugs in what was described as a robbery. Subsequent thereto, he wrote a statement to that effect with the police. Similarly, the second accused person on 28th of September 2018 wrote a statement in support of that report that the first accused person was shot by thugs while going home. 28th September, I've had the benefit of that statement. It's marked as prosecution exhibit number 109. I have read it in its entirety. It suffices to note this. On 29th, the following day, the second accused person writes yet another statement on the shooting incident and retracts what she has said in the statement of 28th of September 2019. This time her evidence and her statement is that no, he wasn't shot at the gate. It's an incident that took place in our house. Now, Brian Kasaine Spira, the owner of the gun, testifies that while asleep, the first accused person went to his house groaning in pain and said, "Oh, Brian, please rush to my house and secure the gun." Remember, the gun belongs to Brian. He's given it to the first accused person. The gun has fired or been fired or whatever. So Brian rushes to the first and second accused house and secures the gun. What does he say about his observation? He says, "I found blood on the floor. And that when the first accused person came to my house, he had blood all over the chest." Who else speaks to these events? The house help. She says that she had noise, and when she went to check, she found blood, she found a gun, and her concern was, first of all, to secure the child from that scene. But she says she saw blood. There is evidence of PW27, Eunice Mohammed, who was the caretaker at Royal Park Estate. He says, no, if there was a gunshot incident at the main gate, I would have known as a caretaker. There wasn't. Kasaini comes back. Remember, Kasaini was a neighbor to the accused persons, and he says, if there was a gun incident in our estate, ingewekwa kwa mtandao ya estate association WhatsApp group. It wasn't there. What does that say? It is the finding of this court that the report made to the police by the first accused person, the statement made by the second accused person on 28th of September was false. He lied in his evidence in this court, before this court. Now, what is informing this lie? It is very clear that Brian Kassaine had given the first accused his gun without authority. And so according to Brian, when he realized that his gun has been used, his first concern to the first accused person was, what are you going to do? And the words of Brian in his evidence is that the first accused person told him, do not worry. I'll take care of that. I will report it as a robbery. Now, let's look at the legal, natural, probable, and moral consequences of a lie. The case of Kinuthia versus Republic, 2003. The Court of Appeal had this to say. I will repeat. Kinuthia versus Republic, 2003, EKLR. The court had this to say. I quote. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. I will repeat. Where the court doubts the integrity of a witness, then the court cannot accept the evidence of that witness. The court went on to say, in a criminal case, a witness should not create an impression in the mind of the court that he is not a straightforward witness. That if a witness raises suspicion about his trustworthiness or does something which indicates that he is doubtful, he has doubtful integrity, he will be deemed to be unreliable, which makes it unsafe to accept his evidence. Please also look at these other cases. Dungu Kimani versus Republic, MTG versus Republic. My analysis of the evidence. In relation to this issue of giving false or denial, the first accused person says, I'd never met the deceased. Court data shows he met the deceased. The first accused person is alleged to have told witness number 7, Owen, I stay in Emali. Evidence reveals the contrary. The first accused person gives the reason why he's wearing a kanzu and says, I'm going to meet people in Isli, from Muslim community. He does not reach Isli. It turns out the kanzu was worn, left, went where he went, came back. And in fact, by the time he's going to meet the second accused person and the others in Westlands at midnight, he has also removed the kanzu. For training, the gun is found evidently at the time the offense is being committed, at the scene of the offense. And of course, his own confession, I lied about the gun shooting. The second accused person contradicts her own statement by the statement of 30th and says, 29th, now I'm clear in my mind. The statement I gave you yesterday was a lie. Statement of 28th was produced as exhibit 109. Statement of 29th was produced as exhibit number 10. Once it's produced in evidence as exhibit, I use it. Before I move to the very last stage of my judgment, allow me to address the issue of contradictions and the law. It is the first accused, and by extension, of course, the second accused again says, look at all these contradictions in the case of the prosecution and find that the prosecution have not proved their case beyond reasonable doubt. The case of John Nyaganjuki and 4 others versus Republic. The court says this. In certain criminal cases, particularly those which involve many witnesses, discrepancies are in many instances inevitable. I'll read again. In certain criminal cases, particularly those that involve many witnesses, discrepancies are in many instances inevitable. Philip Zioka Watu versus Republic. Court of Appeal had this to say on contradictions. However, it must be remembered that when it comes to human recollection, not witnesses recall exactly the same thing to the minutest detail. Some discrepancies must be expected because human recollection is not infallible, and no two people perceive the same phenomena exactly the same way. Joseph Maina Mwangi versus Republic. Lays the legal principle that the court will not disregard the evidence of a witness on the ground of contradictions unless the contradictions go to the root of the case and create doubt as to the guilty of an accused person. And the court had this to say on that. In any trial, there are bound to be discrepancies. An appellate court, in considering these discrepancies, must be guided by the wording of Section 382 of the Criminal Procedure Code, where such discrepancies are such as to cause prejudice to the appellant, or if they are inconsequential to the conviction and sentence. What are these contradictions this court has been invited to look at? Contradiction on the time Aaron went to the house of the deceased. Contradiction on the cloth. Some people said he had a counsel, others didn't say he had a counsel. Contradiction, one witness said, I saw him with a bag, another one, I didn't see him with a bag. In my finding, and it is the finding of this court, the contradictions the defense has invited this court to look at are inconsequential. They do not go to the root of the matter, and the evidence of the witnesses cannot be disregarded on that ground. I am expected to be bringing the curtain down, but I'll go to the last ingredients, those of us who are working with me. And I have to pose a question and answer at this point. Then I'll come and answer that question. And I will repeat the question. Did the first and second accused person kill the deceased? I will answer it. But if, before I answer that question, let's look at the last element of malice aforethought. I'll look at two things, then I will close. I'm sure you're wondering what is the next thing she's going to look at, so let me whet your appetite. I'll look at malice aforethought, I'll look at circumstantial evidence, then I'll close. I'm sure the lawyers understand why this judgment had to be this long. There was no option out of it. Please join me in looking at Section 206 of the Penal Code. And just to save a bit of time, I will not read because I've captured it from the law. Please allow me not to read, I pass. But it talks about malice aforethought shall be deemed to be established by evidence proving any of the following, then it gives the circumstances. Please allow me not to read. But maybe I need to just point out subsection C, an intent to commit a felony. So you'll be deemed to have had malice aforethought if your intention was to commit a felony. Now, in the instant case, what the prosecution are arguing is that even before the day of the murder, the first accused person had already started preparing, premeditation. And so how do they support their submission to that effect? We go back where we were earlier. Look at his conduct before. Look at his conduct during. And look at his conduct after. So let's just do a recap. The first thing is that the first accused person, and I've made a finding on that and we don't have to belabor it, the first accused person stole the ID of Dominic Becerra Harun on 17th of September, 2 days before the murder. And why this court has arrived at the conclusion that he stole the ID is because of two things. One, he resides within the Royal Park Estate where the ID was stolen. Is it a coincidence? Number two, the ID was never recovered. The owner had to get a duplicate. And number three, the witnesses to whom he presented that stolen ID have identified him on the ID parade as the person who presented the ID. So it's not hard to join the thread. And my finding is that the first accused person stole the ID of Dominic Becerra Harun 2 days before the commission of the offense. Secondly, the evidence analyzed reveals that this first accused person, other than the cloth he was wearing, he carried a bag, and the house help has testified that he had a bag. That evidence of the house help has been corroborated by the evidence of Jennings, whom he joined and who was his friend. And Jennings says, yes, he had a bag, and it's in that bag that he removed a counsel. So the question is, why didn't he wear a counsel right from the time he left home? Does the carrying of the counsel to be worn murder and removed immediately the murder part of the plan? Does it constitute? Number three, it is evident that he had borrowed a gun from Kasaini. He was supposed to return the gun after 2 days. He didn't. Then just before he went to the deceased house, he took the gun and went with it. Does the fact that he borrowed this gun even before the due date, or the material date, or the fateful night, part of his plan to commit the murder? The statement to Owen. In other countries, you can commit an offense and walk out with it. You can't walk out with it, but in Kenya, you can commit an offense and walk out with it. Because, and even impersonate, no one would really follow you. We don't have that. What does it speak to? Number 5. The evidence of Jennings. And he says when the accused person came back, he told him that he had quarreled with a girlfriend from South Sudan. But even more so, that when he came back, he looked agitated, he was not in the mood, and seems to be in a hurry, and he didn't want to advance anymore the discussion they had. Republic versus Richard Itweka, Wahiti. Does the nature of the injuries that the deceased suffered speak to malice aforethought? That case, the court held that severity of the injuries is evident that they were inflicted by a person who had no any other intention than to cause grievous harm and kill. Let's look at the injuries the deceased suffered. I'll take you to the doctor's evidence. And I picked this from the post-mortem report, that the deceased airwave had been shot through and through. And the right carotid and the jugular veins had been severed. That is cut through and through. Now, this brings me to what played before this court heavily as I had this case. On very many occasions and during cross-examination, the counsel for the first accused person kept on putting to the witnesses, have you ever slaughtered a goat? And the witnesses would say, yes. And what impression was created in the court's mind? That the manner in which the deceased was killed was akin to slaughtering a goat. And so the argument of the first defendants accused was that if I really killed her the way she was killed, the way a goat is killed, how come the blood didn't go on my cloth? I have had the benefit of looking at the photographs by the scene of crime. And it's very clear that the deceased and the person who killed the deceased did not intend to give her room even for 1 minute to survive. Now, I've said Dr. Njenga said that the airwaves and the jugular veins were cut through and through. So I checked on the functionalities of these organs that were targeted. And this is what I found. The carotid arteries are major blood vessels that provide one's brain, supply blood to the brain. I established that a person has 2 of them on either side of the neck. I discovered that they're actually a cause of at least 1/3 of all strokes. And that a stroke occurs when something blocks blood flow to your brain and causes brain injury. Therefore, they are a very important part of one's circulatory system that sends oxygen-rich blood to organs and tissue in the head and in the neck, including the brain. And then checked on the veins that were targeted. And I discovered from my search and reading, they are major blood vessels that stretch from the upper head, from the head to the upper chest. There are 3 pairs, total of 6. And the reading, my further reading shows that when the arteries and the veins that were injured on the deceased body are severed or they're cut, then no blood is supplied, and the victim cannot even survive for a minute. It's my considered observation, opinion, and finding. And it's noteworthy that this deceased person had injury on the neck only, occasioned by a sharp object. It is my considered opinion the target of the neck clearly indicates that the perpetrator was fully aware, intended to, and did actually target for purposes of instant death of the deceased person. Does this connotes malice aforethought? I did, and I've made an observation. When you look at those photographs, you don't want to look at them again. The slitting of the neck was not just on the front, right up to the back. And I made an observation, it's no wonder then in our hearing we heard of slaughtering of a cow or a goat. The evidence of Chief Inspector Otieno is that the person who committed this offense was not an amateur. He's not a person who has no training in military, or because the way it was done with such precision that you can't go wrong. And so I asked myself, does the first and or the second accused person have any training in military or military training? And that took me to the following. According to the evidence of the prosecution witnesses, and I'll start with the evidence of Jennings, when he met the first accused person, they were on a VIP protection exercise, and it said that that is when the US president was in Kenya. And he says they then became friends, and they were actually discussing how to form a security company. The house help says in her evidence, she asked the second accused person what the first accused person was doing, and the second accused person told her he's a soldier in Dubai. Owen says the deceased introduced the first accused person as a security in Interpol and Office of the President. In fact, according to Owen, they even spoke how he was going to help this witness secure a firearm. Jennings says that the first accused person told him that he had been working with a security company in Dubai. And he also told him that he was offering VIP protection to state officials in Kenya while on leave. According to Kasaini, he gave the first accused person a gun because he knew the first accused person was working as a private military officer who covered several politicians under an undercover, so to speak. That he worked as a private military contractor in Dubai and was guarding the former Senator Joyce Ray. It is the finding of this court that for one to engage in VIP training, they definitely must go through training. And that training would not be too far away from the training offered to a military officer. And if the first accused person went through this and he murdered the deceased, then he had the know-how. The conduct of the first accused person and his conversation with the deceased brother. When the deceased brother told him, look, can you help me get press? Can you ask your fiancé who is in the media industry? It is in evidence the first accused person told him, forget about the media, they won't help you. I don't know, you are here. I have a private company, let me do it for you. What does that statement speak to? A further issue I picked up, he said says, look, the person whom the deceased allowed into her house was Dominic Becerra Haron. And she must have known somebody by that name, and that's not me. And my simple finding on this is this. If this first accused person is introducing himself, I work at State House, I protect the President of the States of America, I am in a security company, I am an undercover, is it far-fetched to imagine that even when he told the guards at Ramuria Gardens, I am Haron, the deceased would not have contradicted that because the deceased also introduced him as somebody who works at State House. So we all know that, hopefully, the court is making a right observation, I think I am, that people who work as undercovers will not quickly volunteer their true identity. And that could inform why, even when he said I'm Haron, and the deceased knowing whom he has said he is, would quickly say, let Haron come in. And then in the house gives him his true identity to the other persons in the house. So I didn't find it difficult in coming to a conclusion that it is explainable. Is this case based purely on circumstantial evidence? And has the prosecution met the threshold of circumstantial evidence? You'll allow me to just pick extracts from the cases. I'm coming to the tail end of my judgment. Cases that speak to circumstantial evidence. Some very critical areas, I think, will guide my findings. Ahmed, Mohammed, and another versus Republic 2019 speaks to circumstantial evidence is often the best evidence. It is evidence of surrounding circumstances which, by intensified examination, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it's circumstantial. Republic versus Juma Kaviha Kalama. Circumstantial evidence is particularly powerful when it proves a variety of different facts, all of which point to the same conclusion. I have given emphasis, my own emphasis, on the following. It works by culminatively in geometrical progression against other possibilities that has been likened to a rope composed of several cords. One strand of a cord might be insufficient to sustain the weight, but 3 strands put together may be quite of sufficient strength. There may be a combination of circumstances, no one of which would raise a reasonable suspicion, but the 3 taken together may create a strong conclusion of guilt with as much certainty as human affairs can require or admit. Emphasis added. Having considered the evidence in this matter, it is the finding of this court, yes. The case is based on circumstantial evidence, but the prosecution has adduced adequate evidence and has met the threshold. And to sum up, did the first accused person kill the deceased? It is the finding of this court. I'll play back for purposes of my finding. The first accused person stole the ID of Dominic Becerra 2 days prior to the commission of the offense. armed himself with a gun, carried a counsel, put it over his cloth, went to Ramuria Gardens, disguised his identity, gained access to the apartment of the deceased, murdered the deceased, left the deceased house, changed his clothes, and eventually went home and burnt the cloth which he wore during the commission of the offense. It is the finding of this court that all this evidence taken culminatively leads to a strong conclusion that the first accused person murdered the deceased. And therefore, it is the finding of this court that the prosecution has proved beyond reasonable doubt all the ingredients of the offense of murder. The death occurred, the cause of that death, the person who, and in this case, the first accused, I'm still on the first accused person, committed that offense. It was not a case of homicide, excusable homicide. It was unlawful. And therefore I find the first accused person guilty as charged herein of the offense of murder, that on the night of 19th of September 2018, at an unknown time at Ramuria Gardens apartment, Kitare Lane off Dennis Prit, with others known before this court, he murdered Monica Nyawira Kimani. The evidence by the prosecution against the second accused person did not place the second accused person in the house of the deceased on the material night. There was no evidence that she had ever communicated with the deceased. The evidence that the prosecution have brought before this court on the second accused person relates to the events of 20th of September 2018, and that is the shooting incident. And in that regard, having considered the provisions of Section 129 of the Penal Code of Kenya, and the second accused person having had no objection to her two statements which she gave the police. One saying that the second accused person, the first accused, was shot in the house, and then retracting that statement the following day, only leads this court to the provisions of Section 129 of the Penal Code, which states as follows. That Section 128 creates an offense, which is an offense of giving information, false information, to a person employed in public service, and states as follows. Whoever gives to any person employed in public service any information which he knows or believes to be false, intending thereby to cause or knowing it to be likely that he will thereby cause the person employed in public service A, to do or omit to do something which the person employed in public service ought not to do or omit, if true state of facts respecting which such information is given were known to him, or two, to use lawful power of the person employed in public service to the injury or annoyance of another, is guilty of a misdemeanor and liable to imprisonment for 3 years. The statement which the second accused person gave to the police on 28th was false. The statement was given to a person in public service. The statement intended that that person investigates that offense. That statement was retracted by the second accused person the following day by a different statement now speaking to what is said to be the truth. There is no timelines in criminal law when you can prefer a charge against a suspect. The Limitation of Actions Act does not apply to criminal offenses. It is my considered view that the charge brought against the second accused person was not the proper charge. Section 157, sorry, not section, Article 157 gives the power to institute and prosecute a person suspected of committing the offense to the office of the Director of Public Prosecution. And the question posed at this stage is, was there an offense committed when the second accused person gave a statement to the investigating officers at Langata Police Station, which turned out to be not true? I say no more. The office of the Director of Public Prosecution know their mandate. The result is that the prosecution did not adduce adequate evidence for this court to find the second accused person guilty of the offense of murder of Monica Nyawira Kimani on the night of 19th of September 2018. The first accused person is convicted on the charge. The second accused person is acquitted of the offense. That is the end of the judgment. We'll move to the next stage. The state you are supposed to go next.
We are the first ones.
So I am expecting the records. If any.
We'll be asking for more time. To present CRO report, which is the previous records for the first accused person who has been convicted. In the meantime, we'll also be asking for a pre-sentence report in relation to the first accused. And we'll also be praying that the first accused be remanded at Maribe remand. As we await to get the previous conviction and also the pre-sentence results. We'll also be praying for typed copy of today's judgment.
Okay. May I know whether Professor Nandwa, you have anything to say? No. The victim's family, Musembi, sorry.
I don't have anything else to add.
Professor Nandwa, yes.
Aside the prosecution.
Professor Nandwa, for the first accused person, you have something you want to tell the court?
Your Honor, first of all, we appreciate the effort that this honorable court has invested in coordination and determination of this matter. And it is brought now to this conclusion. We do pray that we be given time also for us to prepare our mitigation. In favor of the first accused person. We also seek the indulgence of this honorable court that it maintains the bail terms that were granted to the first accused person who is under convict. Is not of life risk. We will avail himself when the mitigation, when required by this honorable court. We also pray that the exhibits that were and other items that were seized from the accused person, which are of personal nature, given that the case has been concluded, to return him and specifically the phones. That's what.
My lady, in the last session we didn't take directions on dressing, so I pray that you excuse me on the dressing that
That's okay.
Thank you. The second thing, and which is very important, is to thank you, my lady, for the attention to detail. You clearly gave attention to all the details, both factual, legal, and the issues in between, and we really want you to know that we appreciate as defense your attention to detail. My lady, for the second accused, we want to say, and you wouldn't want to have taken it for granted. We are sorry for the first accused. We are grateful for the acquittal on the charge that she was facing. And we pray, my lady, for release of the securities that have been put in to stand in as her bail.
You are asking for the release of security?
Yes, we are praying. Yes.
That is surety?
Yes, ma'am.
Well, you realize when this matter was going through that process, I wasn't hearing the matter. So what is it that was deposited in court?
We can go.
I think it's administrative.
Yes.
And for me, it should actually just be a natural process, administrative, unless, of course, the state, as I'll be indicating, have a right to appeal.
And they do not intend to appeal.
I do not know where you get that from. I don't know. That I'll leave to you.
Yes, ma'am.
But of course, if they are not, after 14 days, you can seek for release.
Okay.
We need to give them the 14 days. Okay?
My lady, that's all we have for the second accused, and thank you very much.
Okay, so a matter of this nature, you cannot afford to pronounce a sentence without, of course, a Maribe report, because it is that report that will take into account the views of the victim's family. And so we will stand over this matter to another date when we'll be dealing with the sentence. It will also allow the prosecution an opportunity to seek for CRO those records, so that the court is guided whether this is the first offense that the first accused person has been found guilty of and convicted of. And it will also allow the first accused person an opportunity to prepare mitigation. And then now need to take a date. We also allow the court assistant we take a date for dealing with the sentence. Diary. Listen to my diary. Now, as I had indicated earlier, I'm starting my leave on Monday.
Yes.
I think, Professor Nando, you are aware of that because there are other matters that you have before me. And so, just to guide you, I'll be away from the of February to assistant. You don't have a diary where I can just quickly pick 24 February. 11th of March. You'll be before me on 12th.
No, I'm in a court of appeal matter
on 11th.
Yes.
Okay, so you want us to give you the 12th of March?
Yes, 4th of March will be continued.
You have two other matters that are coming for judgment before on 8th of March?
On, yes.
8th of March.
8th of March. Can you make it on the same day?
Okay.
You are also coming here.
Am I coming here?
Yes, 8th of March.
Yeah, it's a Friday. I come here on a Friday. Okay, 8th of March. Yeah, okay. I thought we were dealing with those matters virtually, Prof. You want me to come here? Okay. That's okay. I can. Okay. May I have the first accused person stand up? You will appear before the court on 8th of March for sentencing. Unfortunately, after conviction, I'm unable to accede and or allow the prayer by your counsel for you to remain on bond. I'm cancelling your bond. You'll be held in custody until the 8th of March. Okay? So that is done. Assistant. Number 5. Here there's another file with Prosecution. So, as I adjourn court, may I take this opportunity once again to sincerely thank the first accused person. Please sit down. The councils who've been involved in this matter. We've had dedication. I don't remember how many times this matter was ever adjourned because the councils were not there. I do not remember how many times, probably the last time the matter was coming for judgment when the accused persons were not there. The state was always in attendance, and we've only been able to deliver this judgment because of that support that I got from the councils on both sides. I want to thank you sincerely for that support you gave the court and, of course, the commitment. There are things that I will not want to speak to, but which, of course, we all know. But our general statement is always good to respect the court and just give the court its due respect. We don't sit in this court as in our personal capacity. I believe what I see behind here speaks to the authority of the court. And in most times, the court will not have an opportunity to respond to certain communications. The last bit of it would be me. And throughout this matter, I knew clearly what my purpose was to deliver judgment and not to get myself into response to social media or otherwise. And that has nothing to do with my decision. It has everything to do with a plea on my own behalf and on behalf of my colleagues and the entire judiciary. Let's support the judiciary. When a matter is still in court, it's just good to allow that matter to be dealt with. Any comments that would probably be adverse are not necessary. Please, Kenyans, support the courts. I'll leave it at that, okay? Otherwise, press, asanteni sana kwa kuja. When I called the parties to come before me on Wednesday and said, are you ready for this judgment? I knew the press had left knowing we are coming on 15th of March. Hope I didn't surprise you. But from the population I'm seeing here, I think information reached you in time. And as I had said, please, for those who may not be able to come to court, make it online. And I had been assured that we'll have an online, but nothing lost. The most important people who needed to be present are in court. So asanteni sana kwa kuja. And finally, thank you for being patient with the court. My judgment is about 117 pages, and it may not take one day to write. Okay? If you want to know my workload, please visit Naivasha. You will understand. So for me to come up with this judgment, I don't want to praise myself, but sometimes it calls for quite a bit of work going into it. So I'll just say that thank you for being patient with the court, and I do appreciate the indulgence. Thank you. Yes, Professor, you want to say something?
Yes, my lady, I wish to reiterate our gratitude to the Honorable Court, effort that you have invested and the attention that you have given this matter. You have always given it priority. We also respect your decision. We may not agree with you, but when we do not agree with you, the law provides for what to do.
Sure.
Therefore, rest assured that we respect you, we respect your decision, we shall live with it, and we shall act and do what the law provides for.
Yeah.
Appreciate your efforts. You have done your part, and God bless you for that. On behalf of the first accused person and the company, we really appreciate. I remember you allowed adjournment more than two because of me. We really appreciate that. And on behalf of the first convict and also the family, we appreciate and thank you very much. And God bless you.
Karibu. Yes.
I had expected my senior to do this already. I just wanted to say on behalf of all the accused persons, my lady, we apologize for any excesses that may have emerged in the social media. In the same way you said you are patient, you thank the gallery for being patient. We want to thank you for your patience, my lady. And lastly, we saw you turn your back and look at the sheet. And we thought that was calming. Thank you very much, my lady. We want to say we are grateful and we apologize for any excesses.
Thank you.
My lady, equally for the prosecution, in fact, I should have started by thanking the court for the patience and also for expediting this matter, because it's been a very long journey. We've handled it before different judges, but at least when you came about 2 years ago, you picked it up and you have managed to conclude it and for the hard work that you have put in.
My lady, on behalf of the family of the victim, we are most grateful to the court for the diligent work that went into the judgment, the analysis. We thank you for bearing with us sometimes, bearing with counsel, with the media, even when we may have not pleased the court. So thank you so much.
I want to assure you this court is extremely at peace, and this court takes offense on nothing. Okay, so with that, kindly may I request the court assistant, we now officially adjourn the court. Have a good afternoon.
File ndio ya maana. Atajichukulia, nawekea tu hapa.